how did you handle, so I can compare notes to how did you handle chapter 61A and B land? They're asking the planning board for their recommendation.
61A requires planning board, conservation commission, select board, and recreation commission to opine on it. And Wiles is put on the planning board agenda, and the planning board will vote. In almost every case, they voted to indicate they had no interest in acquisition of property. There's only one or two times that all the departments, all the boards said, yeah, we want to acquire the property.
Yep.
That's how we always did put on the agenda. Memo to the town administrator, the select board, indicating what the board voted.
Richard.
There's one time that the school department indicated, oh, this property for new elementary school. So, okay. So they required it. And then they found out they couldn't use it for elementary school.
I was just asking him, to handle it in South Hadley, and it was the same way we do, basically. There's a parcel coming up over off of East Street, I believe, somewhere.
Yeah, I know where it is, yeah.
So there's the letter from the attorney on how we want to act on it.
Right, I think Conservation Commission acted.
Hello, everybody.
Oh, I think you should sit here, Paul, am I in your spot?
I'll sit anywhere.
I'll sit here, I'll move down the stairs.
Yeah, Dan's not coming tonight. Dan's
You
sick.
could be there, you're the, in terms of order.
I get to
But
play
anyway,
footsie with Paul.
I think Conservation Commission acted on it the other night, open space.
Oh, would you
Commission.
grab that other agenda for Paul for me, please?
Here, I got this one. Here.
Copy.
In terms of order of election.
Cindy was active in that open space committee, so she was concerned a couple of times about how it was handled. I said, well, we defer to the people that might have the money to buy it if they're interested in it, you know,
In each case, the statute requires those boards be notified and they indicate interest in it. And what we always did is that if it's like a 1 acre piece of property, unless it's tied into a trail or some type of significant location,
The one with the wheels,
It's in your house?
yeah. That one had the rubber wheels, and, I just wiped
There we
them off
go.
and figured we'd keep it inside for now, Can't go back and forth, obviously, but.
I believe we're live, so I can begin. This time I'm going to open the November 3rd meeting of the Southampton Planning Board. All members are present tonight except for Dan LaValle, who is asked to be excused. And we don't have much of an agenda tonight, but our main focus tonight is bylaw revisions with our consultant Richard Harris here, who's going to join us. And everybody had gotten emailed some more draft material, so I'll let Richard take the floor.
It's difficult to speak with masks on. First item is the common driveway bylaw reformatting condition. At the last meeting, the board reviewed it and gave me some comments, and I think I revised it to reflect those comments, and I guess I'll find out tonight if I did or not. So I'd like to just ask if there's any comments on the revision to it, if there needs to be any further edits to it.
Everybody have a chance to look at that? I wasn't here and I looked it over, but I don't know what you may have been discussing on it.
In the revision, I tried to highlight the items I made changes to.
Okay,
And I will note that in reference to the U.S. Postal Service, NDCU, NDVCU, they've changed the terminology somewhat in Postal Service. I made that more broader classification.
what page is that?
Page 5 of the,
I was looking at page 3, where you had highlighted the width of the right-of-way easement. So the right-of-way is being stricken and you're adding easement?
yes.
Okay.
Easement is more accurate reflection of what it is.
Okay. And page 5, what paragraph?
At the top of item 2, on the U.S. Postal Service approved cluster box neighborhood collection, they've used different terms in the past, and I did some research, and they consistently refer to it as a cluster box neighborhood collection, and stopped using the abbreviation apparently. Again, right-of-way stricken, wherever right-of-way is located, I would change that to easement.
Page 4, number 5, you have the subsection A. The A should really be a standalone number like 6. It's talking about vehicle, it's talking about the vertical component versus the terminus of the turnaround, which is more of a horizontal component. So I recommend you just make that as a,
Item 6.
make item A, 5A as item 6.
Any other questions on the board? Any other on that, Richard, that you want to discuss?
Do we need to discuss the questions at the end, or?
Yeah, I had 4 questions at the bottom on page 7. Do you want to require a performance guarantee for completion of common drive? The big issue with that is that involves using the money to build the common drive. You do that with streets, but the expectation is the street is going to become a town property. A common driveway, by nature, is never to become a town property. So I'm not sure there's a benefit to having a performance guarantee for it. I think the covenant agreement that basically would prohibit them from selling units, transferring units, lots, is sufficient leverage to get the party to complete it without trying to inject the town into the financial dealings of private property.
So I guess my one question on that discussion is, what if you have a parcel that is on the far side of the shared driveway, or the road was not done, or the shared driveway is not completed? You have active residents on various portions of that shared driveway. And what if it's a safety concern? Is that something that we should be particularly, meaning they didn't put any pavement down, they put in gravel washes away.
There shouldn't be any houses there, because the covenant agreement prohibits the transfer of any lots out and prohibits building on those lots until the common, so if somebody's got a common driveway approval, you've got a covenant agreement that says no transfer of lots and no building permits until the common driveway is completed.
And that's stated in the,
Right. That's stated, that's
So that
the
takes care of
provision
that
of the covenant agreement.
yeah, okay.
Unless the planning board releases the lots from covenant agreement, which they shouldn't do on common driveway. On subdivision street, you would release lots from covenant agreement in exchange for financial performance guarantee. And the town does that with the expectation that if they don't perform, the town is going to call the performance guarantee, hire a contractor to complete the work. And again, the expectation is a roadway will eventually become a town road. A common driveway, by nature, is never become a town road.
Right.
So the question I pose is, should you have a performance guarantee beyond the covenant agreement? To me, the covenant agreement is a extremely strong leverage to get the work done.
Yeah, that makes a case for not having it.
The exception would be if you have a performance guarantee for buffering, landscaping, storm drainage. Those have implications for adjoining property owners and for the community as a whole that is significant. But that is separate from having a performance guarantee for the construction of common driveway. In South Hadley, we didn't allow common driveways, but we would oftentimes have performance guarantees for landscaping and buffering, and in the decision on those, we'd make it very clear that it's distinct from the performance guarantee for stormwater, because of different reasons for it.
So are you suggesting we include the performance guarantee for the buffering landscaping, at least that one?
I would suggest allow the board to impose that, but just reinforce the idea that there is not a performance guarantee for the construction common driveway, because that is covered by covenant agreement that's clear that you can't build. It's on page 6, Covenant agreement shall provide that the covenant agreement will not be released and no individual lots transferred and no buildings erected until the common driveway has been constructed and passed all periodic inspections by the town or its authorized agents at specified stages. So the covenant agreement should be ironclad on the completion of the common driveway itself.
That makes sense.
So just to clarify, right now, the way it's worded, we'll leave this performance guarantee paragraph in saying the planning board may require it? We're talking about fully deleting this.
Suggesting that it be worded not for the common driveway, but for landscaping, buffering,
Yeah, as
storm drainage.
As a condition,
A
right?
special condition.
a special condition.
Okay, so that paragraph, that .9, performance guarantee will be changed to
Yeah,
say that
9A be changed,
may require for special conditions.
yes.
Isn't that similar, this roadway that you're speaking about, similar to subdivisions, that subdivisions can't really build, have any lots built on until the subbase is put on, the road's constructed, correct?
Correct, but typically a subdivision begins with the covenant agreement. And at such time as they build the subbase, putting the infrastructure in there to satisfactory condition, they typically plan will release the covenant agreement in exchange for a financial guarantee of the town specification, either cash, bond, or some type of surety. And there's a, yeah. Again, that's intended that the town will eventually take over the roadway at some point down the road.
Is there anything else we need to straighten out there with that language then, outside of that buffering as a condition?
I would also note that I think that the special permit should have time limitation for completion of the common driveway. My concern, there's common driveway, somebody could begin it, grade it, even put a base down, and then run in financial conditions, and 5 years later, it's there. And so there needs to be a condition, and the landscaping, the special conditions should provide sufficient leverage for them to restore it to its previous condition.
So you're looking to define the completion time, what, 2 years maybe?
2 years, I would think be more than sufficient.
Right, 2 years? Or is it 3? Are subdivisions here 2 or 3?
Typically, it's 2 years.
2, right, yeah. So I would suggest not any different than subdivision, right?
So, I have a question. Under 6B, each landowner served by the common driveway shall be jointly and severally responsible and liable for the repair, maintenance, portions of the common driveway, blah, blah, blah. So what this says is that every party that's going to use that common driveway have to share in the responsibility for maintaining it, plowing it, et cetera.
Correct.
Correct. And that may all be well and good with owners A and B, but then owner B decides to sell to somebody, and yes, they know it's a common driveway, but they're not really easy to work with. Does the old owner of A, who always got along with owner B, but no longer have owner B, now they have owner G, do they have any recourse or any remedy for so-and-so's not doing his or her share?
I think it's all tied into the real estate agreement, isn't
It
it?
is. It's tied into the easement agreement that they all have signed in onto, and very frankly, it ceases to become a town issue. It becomes a private party litigation issue. And that's why attorneys.
Make money? Yeah, okay. All right, I get it. I just wanted to ask the question because that would have to be, it's based on the purchase agreement and the agreement. This is a
Typically,
common driveway
the
and-
easement will give the rights and responsibilities to it.
Okay, all right. Mhm.
Which when they buy, I mean, they have that in the deed, so they're kind of,
Yeah, if
they should know.
they didn't agree to it, then
I mean, it's
the sale would go down the drain.
similar to an HOA.
Yeah.
Similar to what?
An HOA, homeowners association.
Okay.
Similar to that.
Okay.
But you're right, it does run into problems, and I used to have fun, we didn't allow common driveways, but we had old driveways that were like that, and our routine response, and if people didn't like it, was, you need to talk to your attorney,
Sure.
and that's a private party issue
Okay.
for y'all to resolve.
Okay. Understood.
Anything else there? We're all in agreement that construction should be completion 2 years, okay?
Seems more than enough time.
Does that address any, like, weather issues or?
But they can always come for an extension.
Right.
Oh, they can ask for an extension in that case, okay.
Yeah, you allow extensions for good cause. Good cause being unforeseen conditions such as weather.
Okay.
Another good cause could be if they're putting water line under it. What people run into now is not being able to get pipe.
Okay. I always defer to Paul and Sarah to come up with the good questions.
Well, they can't get pipe at the right price.
I've been told the pipes, certain pipe ain't there.
Oh, it's there for price.
You good on, anything else you want to cover on that?
No, I think that's takes care of that.
Good on common driveways? All right, what's your next move?
I'll also provide at the last meeting the draft rewrite of the board's policies and procedures. And I would want to know one thing about this is, where I see this project being done, it's been about 4 years now, I think, in the process. What I see being done is completion of the codification, reformatting of the existing provisions, updating those, and then taking on new sections of the zoning bylaw. As you take on those, the policies and procedures will need to be updated as well at that time. Because each time you add something to the bylaw, you could very well require a change in the board's policies and procedures. Because it may be that Section Z requires board to adopt rules and regulations governing that particular submittal application, application submittal. So I want to say that, that whatever you do here is likely to be changed as you go through the rest of the process.
Now, are you gonna, you probably flag those as you go through, correct?
Yes. In fact, what I would plan on doing is attaching a list of what needs to be updated as we go through that. So, and one of the things I noted is your approach to abutters is a 300-foot radius. That's not how state law is written.
There was two schools of thought on that, 150 and then 300. There was like two different versions of it here, and to be on the safe side, we used to use 300, but there were, and I never could understand what the difference was between, I thought maybe larger projects with 300 feet and smaller projects with 150, I don't know.
In state law, for planning board purposes, there's not a radius per se. What state law provides is parties in interest. Parties in interest are basically defined as being persons who are abutters to abutters within 300 feet and those across the street. That's essentially what it boils down to. If you took a 300-foot radius of piece of property, you're going to encompass a lot of people that are not abutters. It took me a couple years in South Hadley before the assessor got me to understand what the state law actually reads like. And It's a strange, bizarre. So it's not actually a radius, it is abutters to abutters within 300 feet. So if you're got this lot right here, and there's a lot on each side, going down the road, on the same side of the street, they're all 120 feet wide. Once you reach 300 foot, then those lots would cease to be, anything beyond there would not be abutters. On the opposite side of the street is strictly lots opposite the subject property. Only those lots opposite the property. It is not within 300 feet or anything like that. And that's the difference. That's the reason I note that you use 300-foot radius, and that's not exactly the way the state law is written for under Chapter 48 or 41.
You've been doing that for years.
So I want to make sure I make that point, because it is different from what state law is.
Now, are you going to go page by page with your highlighting, or are you just going to jump to what you thought was important?
I was going to mention that, and then just basically leave it up to you to decide if you want to go page by page, or anybody has any questions, comments on it.
Why don't we do that? Let's go page to page and just your highlighted areas there that you're concerned with, in case there's any questions here from the board. So on page 1, meetings are in a public building as noted on the posted meeting agenda. That's pretty,
As opposed to stating the address, just leave it general.
right. Section 3, you're taking out definitive subdivision plan, special permit for erosion sediment control and stormwater management common driveway. You're eliminating that?
Right. The reason I'm doing that is those are items that are subject to public hearing.
Our own special permit anyway, right?
Either, well, definitive subdivision plan is not a special permit, but they require some type of public hearing on these items. And I would suggest that person shouldn't be seeking a preliminary discussion on those items until they submit the application. Yeah, any special permit should not be on there either. So basically just be preliminary subdivision plan, which does not have public hearing, a building permit, A&R, those type of items can be placed on there.
And the contact information, that's pretty academic.
And I include the vice chair as well in times where the chair is not available.
Geez, I better get your phone number on that website too.
Oh, I changed it. Did I tell you that?
Did you?
No.
Page 2, you've got under paragraph 1, B1. Go ahead.
Yeah, the
21-day limit.
There's a provision that failure to submit without proper found notification or to not take up an item. You may make exception on that on A&Rs because you have 21 days to act on it. And if, let's say, somebody submits it yesterday and you're meeting today, but for some reason not going to meet again until December, you might want to just take it up anyway so you don't have a default approval.
Yeah, that rarely happens with it. It hasn't happened that I can recall. Usually they're taken care of within a 2-week period, so.
We've usually had that no problem, but we've had occasional time where we had to tell somebody, we don't have time to look at it, we're going to have to deny it unless you give us an extension.
The only time we were pressed for it was somebody said, oh geez, I've got to have this signed immediately, and it was in between meetings because, you know, our closing date, or we've got something, it's not my problem, I'm sorry.
Yeah, my big response usually to that is, let's see, knowing how busy surveyors are, they've been working on it for at least 3 months. Your attorney's known about the closing for probably 3 months. What's the problem?
Why so late? All right, how about, this is an interesting one, the D, about the house number assignment. The only way we handle it right now is when we get a request. or when an A and R comes in, if there's nothing assigned to it at that point, then we also take care of it at the A and R meeting.
The main point I was making with this is that under open meetings law, the agenda has to provide sufficient indication of what the topics of the meeting is going to be. So if you're going to take up a house numbering as someone doesn't get put on the agenda, it's just going to be submitted, considered, you could just have a standard item on your agenda, consideration of house number request. And that way the public knows that the board may be assigning house numbers. Just make sure that you comply with open meetings law.
Mhm. Okay, page 3, down the bottom. E,
Yeah.
data submittal, etc. Date of receipt shall be, by the clerk, shall be considered a date which starts the clock ticking on the
Right.
filing.
Yes, in your existing provision is that it doesn't start until it's deemed complete. That's not what state law is. State law is when town clerk stamps it or you receive a meeting, the clock starts. I've always made point of having town clerk stamp it, so there's a independent body that has put their date and time on it, and anybody wants to question that, that's the date we're going by. So I'd suggest that we indicate that we use town clerk as the date time. And what we have done is if somebody submits an application that, okay, we're now at a meeting and, hey, you didn't have X, Y, and Z on it, you need to have that on it, and the time frame's going to lapse, well, the board can deny the application for failure to have a complete application. So, Mr. or Ms. X, if you wish us to consider your application, you need to give us a written statement extending the deadline for action and provide us the additional material. Or the board can vote tonight to deny it for this basis. And that's a much cleaner approach too. And I have yet, in all my years' experience, found an applicant that would not agree to an extension if they were told they're going to be denied.
Let's see, moving right along, page 5, top of page 5.
That's a continuation of the previous one. Oh, no, 5-4, okay. And that's what I mentioned earlier about the abutters.
So, does the 300 have to be stricken from that, or no?
Yeah, I would just use the reference to parties in interest, and we'll use that as a standard.
So when someone goes to the assessors to get a certified list from now on, or going forward, what are they gonna ask for? And what is the assessor gonna know what the law reads in?
They should, because the assessors are the ones that have made me aware of what the wording is. And they're going to ask for parties in interest as defined in Chapter 48, Section...
Right, so you're gonna rewrite this, is that
Right.
it?
Yes.
Parties of interest.
That's kind of subjective, parties of interest, you know?
No, it's not. State law is pretty well clear about it. State law states who the parties in interest are.
Now, question about, what's the state law regarding, does everything have to have a return receipt
No.
requested? Or is there only like certain special permits that require that?
There's no requirement for return receipt.
There's no requirement?
No requirement. All that's required is that you notify the abutters. Now,
Now, who-
communities that, my experience has been communities that required return receipt, the applicant was submitting the notes to the abutters, or we used to do it in South Hadley because I had a number of people saying, I never got notified. So we started doing the return receipts, and I found out those folks simply refused to go and pick up the mail from the post office. They didn't sign acknowledgement. So we had evidence from the Postal Service that they attempted to deliver it and it was undeliverable.
Right, so can someone question, so if there's no return receipt, can someone question, say, well, who mailed them?
And yes, they
Most of the-
can.
Most of the time, I have recently, not with subdivisions, when subdivisions come up, something that large, the applicant has been doing it, but for, odds and ends and stuff like that, they present me with the abutters list,
Mm-hmm.
labels on the envelopes, et cetera, and the postage, and I personally mail them.
And that's sufficient.
But there's no receipt required of any
No.
sort? Because I asked the post office one day when I went in with a bunch of them, I say I had 18 or 20 of them, I said, can I get a receipt for showing that I mailed these? And she said, no, you would have to fill out a slip for every one of them showing proof of delivery, but not a return receipt, but
Right.
proof of delivery. I gotta take and fill out 18, 20 forms.
There's no requirement in state law of return receipt.
So it's the
there-
honor system.
It's the honor system. Basically, if somebody challenged it, you would sign an affidavit that you deliver them to the Post Service. And they were properly postage, these are the addresses we send them to, and that would be accepted. Because some people simply will not take a certified letter.
So you don't, they don't even require it for a subdivision, which is usually the hottest item that people are interested in when the subdivision comes around. So we don't even have to do it there.
No.
Could you do it if you could, when we can't even request it, correct?
You can require it, yes. You can say we're going to require certified mail postal return receipt, and that can be part of your requirement.
The other one that we had, that was not controversial, but people were interested in it, solar field. And I thought it was a good idea to require them for a solar field because of the size of it. In addition to subdivisions, I just think it was a good practice that something of that magnitude, people should, that way there they can come back and say, well, we didn't know. Well, yeah.
I would be more concerned about anything involving special permit having return notifications, because that's my experience. People are more upset about special permit projects than they did about subdivisions, because subdivisions tend to be small in South Hadley, and special permits was something that everybody got upset about. I don't care if they live 5 miles away, they got upset with it.
Okay. Where are we at? Page 5, you're gonna, in the middle of the page there, A, delete and shall be canceled, right?
Right.
Failure to provide proof of butter notification, the first meeting shall deem the meeting to be improperly noticed, okay. Page 6, down the bottom of the page, applications, waivers. Suggested the board can waive any application requirements set forth in town bylaws or regulations. The board can only waive provisions of laws where the authorizes them to do so.
Yeah.
You
It just needs to be clear that to the extent allowed by state law or town bylaws, the board may grant waivers.
Sorry, can we take one step back there? We just talked all about the certified mail return receipt requested. Are we gonna strike that? Are we gonna remove the return receipt requested going forward since we're not doing it? Or-
I think the wording that we probably want in there, because you said we could, it was may require, right?
Right.
May, somewhere in there, may require?
Or the board can just say the board will require unless the applicant requests a waiver of that and the board determines as appropriate. You could just make the standard that we want all return receipts, but applicant comes before the board and says, there's only 3 abutters, and I've notified them, and they've given me letters of support, and you say, okay, we don't require return receipts then. It's,
I think it makes more sense to say may. I don't know. I was thinking may makes more
Yeah,
sense.
right, may require return receipt or certified, however it is.
The applicant pays all these postage fees anyway, right?
Yes.
Yeah. So you skipped over the 2 open spaces there. One is under legal notices within blank days of receipt of the application, the planning board shall provide the applicant with a copy of the legal notice. Do we need to put a number in there?
we do at some point. I don't know what that time would be at this point in time.
So if we have to give them, they have to publish it twice in the paper.
Right,
It's got to be, what, 14 days before the meeting, right?
at least 14 days.
So typically, I get it, I have been mailing it just before the first publication. So would that be considered 14 days, or should it be 21 days, or?
Are they running the ad, or you send the ad in for them?
I develop it with the information that's on their application, and I send it in, and then I send them the proof with the invoice.
You send it to the publication?
Yeah.
Yeah, okay.
Shouldn't it technically, if the legal notice has got to be postmarked?
If they get the notice 2 weeks before the public hearing, they have ample notice, ample time to get it to the abutters. There's no requirement that the abutters be notified by a certain period of time. It doesn't say you have to give notice 3 weeks in advance or that sort. So I would say that within a week. How long does it take you to write the notice?
You do it in about 10 minutes.
Okay.
You know, and they're pretty good about responding with the proof right away.
And I would say that within 7 days of receipt of the application, the planning board shall provide the applicant.
Okay. And then down the bottom of page, we have a separate schedule for fees, but is that why you left that blank, to
Yeah.
refer to that?
We'll refer to that when we get to that point.
Okay.
So number 2 and B, legal notices, it's not highlighted, but that note, I think, was yours, Richard, should require reimbursement prior to completion of the public hearing. I agree with that. I mean, I think it should be required prior to the public hearing.
I should have highlighted that. Yeah, I would agree that
Where are you, in the bottom of page 5?
on page 6, under B2,
Yeah.
I have a parenthetical phrase,
I got you.
note should require reimbursement prior to completion of the public hearing. That should be prior to commencement of the public hearing.
Yeah, I agree.
Commence, should require.
What I always required applicants to do is provide all funds prior to the chair opening the hearing.
Yeah, that's what we've been understood. Some of them bring it the night of, a lot of them paid it in advance.
Yeah, but the existing wording says the cost of advertising shall be reimbursed by the applicant. Reimbursement of all outstanding costs shall be complete prior to issuance of final approval.
No,
Now, that needs to be before the hearing commences.
prior to the hearing is right, yeah. Good catch, Sari. Now we go to where? 8, 10. The next edit I see is on page 12. Public hearing, special permit granting authority policies and procedures in accordance with section 340. You're striking that
All right. Just
redundant. Page 20, major site plan review. Or, I'm sorry, I changed my glasses here, minor.
I added that in there. In different bylaws, you refer to site plan approval as one process and site plan review as another process. Site plan approval is a step in the site plan review process. And what I know we did in South Hadley, and Larry and I talked about, and other communities have increasingly done it, is you have site plan review and then create a provision for a minor site plan review. So that, and typically minor site plan review does not involve projects of as significant as most site plans. And typically, one of the main reasons we did in South Hadley was exempt uses. We required educational activities, churches be subject to site plan review, but you're limited in the scope of that review. And so when we created minor site plan review, said those are subject to minor site plan review, which didn't require a public hearing. It did require a public meeting. And the reason public meeting, but not a public hearing. Right. And main reason we went that route was people were getting frustrated. They come to a public hearing on a site plan review for church or education, nonprofit education institution, and they'd have these concerns that are outside the scope of the board's review, and they'd leave saying, why did I come to this hearing if I couldn't have a voice in it? Well, so we understand that, so we did a minor site plan review process that didn't require, it still posts on the agenda, you still have all the plans available on the website, but it didn't require notice of abutters to public hearing, and allow the board to focus on the limited scope that they had.
And this is a good add, and I'll tell you why, and you'll agree with me. Two reasons, the Christ Community Church and group homes. Now, group homes came into this area maybe about 5-6 years ago. First one was on Coleman Road, when Tiffany LaBrie was on the board. And we had no idea about it till a neighbor came up and said, you know, what's going on here? Now, they were exempt because of their status, as well as the church was. And while we couldn't bring them in for a hearing, we did want to see what they were doing. The church, by the way, needed stormwater, so that kind of took care of that. But the group home, we had somebody come in.
They still had approval.
They had approval, but we had to make sure that they were sensitive to landscaping and buffering and stuff, because their driveways and their parking lots were pretty good size in a residential area.
Right.
So, and a couple of them balked at it when I called, you know, we don't have to come in and see you. I said, well,
Not to go on a tangent on this discussion about this, but I think the meeting that we had last, or when I attended with Rich, there was a discussion about it being changed from a zoning bylaw to a general bylaw requirement.
The stormwater, yes.
Well, no, for the group homes and the
religious and
religious.
schools.
Didn't we talk about that like
Yeah, we
a month
did.
ago?
I don't recall.
You made the point to us that if it was a general bylaw, then that would apply to churches
Right.
and other types of.
I know we talked about stormwater at that time, and stormwater is a general bylaw. It used to be a zoning, but now it's a general bylaw in Southampton.
Right, but for other considerations, I guess, where
Yeah.
that might fall in.
Animal, street lighting, for instance, or parking lot lighting, noise issues, those should be a general bylaw, not a zoning bylaw. I mentioned that years ago I was tasked with developing a bylaw for elimination of parking lots. And the reason for that was Mount Hood College is going to build this, redo the athletic facility, and it's going to have a big parking lot, and residents were concerned elimination there. So the town minister said, no, we need to bylaw for this. It did. I started doing a zoning, and Bob Ritchie at the time was at the municipal law unit of the AG's office. And he told me, he said, one of the biggest problems is communities do too much under zoning and not enough under general bylaws. And one reason for that, his concern was that if you did under zoning, nonprofit education institution, churches, any of those exempt uses under Chapter 48, Section 3 would not be subject to those provisions.
Under zoning.
Under zoning. If it's a general bylaw, they're subject to it.
Oh, well, then that's, answers that.
So if you can reasonably do it under general bylaw, do it there and not zoning, such as parking lot illumination, stormwater, wetlands.
How about site plan though, for the same entities?
That'd be more of a challenge. You can still do site plan review, but you can't, you still have limitations as to the scope of that review. Because if you try to apply zoning items, zoning standards to a general bylaw item, you're going to run afoul of the AG's office. For instance, if you're allowed to regulate on parking, you're allowed to regulate on height, bulk, those areas. If you have other regulations in your zoning that would not apply to them, and then you say we're going to do site plan review on general bylaw and apply these, any standards under your zoning would not apply.
So,
Outside
just,
the scope.
I think just from a point of clarity, in terms of the general bylaw review, obviously you brought up some major development concerns, from a parking to a building to other type of discussions that should be discussed under general. From what I'm hearing from you, it sounds like that needs to be carefully crafted so it doesn't violate
Right.
other provisions that would be deemed more likely in the zoning.
Right.
That would fall under.
One aspect that's to be kept in mind is there's nothing in state law that talks about site plan review. If you looked at Chapter 48, Master and Law of the Zoning Enabling Act, you will not find site plan review mentioned anywhere. That was a tool that was developed apparently by planners about 30-something years ago, maybe 40 years ago in Massachusetts. And the AG's office, okay, so it's regulation of by right, and they're just simply looking at site plan. Okay, that's fine, and let it go. So that's what you can do on that is still vague because state law doesn't address it.
All right, so if it's not site plan, then it definitely is special permit.
Yeah, yeah. And typically, special permit involves a site plan as part of the special permit
Funny,
process.
in Northampton, when I was on the board over there, they use that term all the time. In fact, it used to be a combined meeting, so to speak, same site plan, special permit site plan review meeting for this application. They used it both, but probably it was redundant.
It was, and we did in South Hadley, but mainly because site plan approval is a simple majority and special permit is a supermajority approval. And a good example being, we had a bank. They're taking a old gas station at the corner of East Street and 202 and converting it into a bank. Is it Easthampton Savings Bank? Yeah, ESB. And the bank was allowed by right, by site plan review. But they had
an old sign that they wanted to use that was non-conforming. And that aspect of it was a special permit. So it actually worked to their benefit because we had one member of the board who was opposed to allowing them to reuse the sign. The other 4 members had no problem with it. And the board approved site plan review when there was only 4 members present. And then the next meeting, when all 5 members were present, they approved the special permit for the sign. So that was the case where we actually separated the 2 issues. Because the majority of the board, over 4 out of 5 members said it's a great idea. Because the design looked really good. But, yeah, so again, site plan review is not addressed in state law. There has been efforts to get it addressed, but it hasn't passed legislature yet.
You wouldn't use the term minor special permit? No?
No. I think special permit is a specific item under Chapter 48, Section 9 that,
All right, so what do we have to do to get religious and education into the general bylaws, or are they in there already?
what are you wanting to regulate on them? What are you wanting to regulate on all uses? They're already regulated by parking, well, reasonable regulation of parking,
Lighting?
height. Now, lighting, now you could have a general bylaw that addressed lighting, and you wouldn't have to you don't want to name a use that you're regulating. You want to have a general bylaw that regulates lighting, outdoor lighting.
How about landscaping? Is that a?
You could have a general bylaw that regulates all outdoor landscaping for institutions other than single-family homes. I'd not recommend regulating landscaping for single-family homes. That would be a nightmare.
How about vehicular traffic impacts or things of that nature? Is that something that you can?
Traffic study, no?
That'd be really tough, Dave. You can already address that to a certain degree because under 48 Section 3, they're subject to reasonable regulations related to parking. So if somebody came in to build a expansion to a nonprofit education institution, substantial expansion, or church, you could reasonably say, we need a traffic analysis so we understand how the parking is going to work and make a determination that the parking is sufficiently designed to address traffic concerns. I think you can already do
I'm
that.
talking more so about, I guess I'm just trying to tie in off-site mitigation.
Off-site mitigation is tough to do for any use.
Right, but usually you have,
The leverage you have in off-site mitigation, very frankly, for private developers is, okay, I can challenge it, and it's going to take me X amount of months to do so, and X amount of money. Off-site mitigation is going to cost me this amount, which is the cheaper and quicker way to go.
right, so that's always the formula that they're
Right.
looking at.
Nonprofit institutions don't necessarily look at that.
No, but that's where I'm going with this, and I understand you can't pay for mitigation that, where there's mass general law prohibits or
Right.
doesn't,
Had the impact fee approach. And
right, it's not the same as somewhere else in the country, but in terms of having something that has teeth or ability, and I understand the challenge, there's nothing really there for you to tie back unless there's unless there's some bartering or some cooperation between the town and or agreements between the town and developer, nonprofit, it may be, but I'm just thinking out loud, and I'm just wondering if there's any protections or any.
Let's take a look at that and see if there is some approach we can take on that. because I think it is a challenge.
I was thinking, you know what came to mind, what's the big, is it a Slavic church or whatever on Route 20 in Westfield?
202. Well, there's one else over 22.
Yeah, but I mean, the sheer size of those places and what they attract on a weekend or something, and that's what came to mind is the geez, you would want to have a little bit of say about the traffic impact there on a weekend.
Yeah, the challenge you have is the 48 Section 3 gives really broad exceptions now. But what you could do on something like that, do you have a driveway permit bylaw? Or they have to get
I know that's what Randall was working on.
Highway has something.
If there were a driveway permit bylaw, I think that could require a traffic impact study, including off-site, as part of the condition of issuing the permit. Because one of the issues you have with issuing driveway cuts is what impact is it going to have on this intersection and that intersection? It's usually related to the placement of it and the size of it. But that also drives into the size of the generator too. If it's a 12-bed group home, doesn't have much generation impact. If it's a 5,000-seat mega church, that's another story.
Yeah, but can a driveway permit can't be so explicit as to trigger traffic studies, can it? All you're really talking about is a curb cut, aren't you?
Well, it's the basis for, it's the criteria that is to be used for determining whether or not to issue the curb cut.
Well, yeah, but then the so what also comes into play here, right?
Yeah.
The big so what, it's like, so they require, so let's say we get to have them, whoever the developer is, develop or produce a study that says that, okay, you're gonna be impacting X, Y, and Z. The so what now? There's no mechanism for them to be.
And if the impact is determined to adversely impact the intersections of the roadway or the traffic flow, the driveway permit doesn't get issued or is conditioned upon revision, improvements being made to address any impacts.
So you can tie that back into the general bylaw.
I think I would take a look at that and see if we could.
Good, now I can go to the bathroom.
We'll take a brief recess.
There has been a question that's been asked in the past, but I'll research that.
So that's the only thing you had on minor site plan review, then? It's just, you're adding that section?
Right.
Okay. And then, last page 22 is just some fill-in numbers
And
here.
blanks.
On blank, this is a,
This historical record of it.
yeah, this is the decision, right?
This will be procedural history. It's something that the town council in South Hadley got me into doing when I wrote up planning board general bylaws, general rules and regulations. They had me put in procedural history, so there's a record of when the board adopted, when they amended it, et cetera.
Gotcha.
And I thought it was a pretty good idea because we were going back trying to figure out when the board did this, when they did that, and
Now, this doesn't have to go to public hearing, policies and procedures.
no.
No.
Board can adopt those anytime they want. I've always recommended that a board hold a hearing on them, just be nice to everybody, but,
We want to be exempt like the churches and the education. We want some exemptions here. You want them to weigh in on what we want to do? How we want to conduct our business? Oh, dear.
I used to have the planning board hold public hearing if they wanted to amend the fee schedule.
Well, no, we never did that. We, you know, last time we updated that was done here at a regular meeting. What do you want to tackle next? Site plan review that doesn't exist in
State law?
State law.
I given that, I made some tweaks in based on what Larry had given me, but I want to look at that again based on some other stuff I've came across. So let's hold off on site plan review at this point in time.
Okay.
I guess we should talk about the budget and,
Now, this was just
This most recent
the
batch.
table of contents that you sent through, right?
right, and
Sheets
I need to say that.
and the graph you had.
yes, and I've updated the status of codification of, and updating of, and new provisions.
Okay, so status of codification updating, okay.
For instance, I noted that erosion sediment control for stormwater that actually has been deleted from zoning, that's now a general bylaw as of,
So that's coming out of the zoning bylaws entirely, right?
it already has, yes. At the last meeting, I talked to the board about how I viewed this project proceeding, and I know there's some question about how much money is there, and I just want to be sure we're on the same page as how I'm proceeding on this. What I've been doing is focusing on codification and reformatting of the existing provisions. And what I'm now doing is, I've done all of those, and now I'm going back and I'm at the bottom of each one listing questions and comments I have regarding each of those sections. For example, in the multifamily section, I think there's some serious questions about some provisions in there in terms of their having an exclusionary housing impact. And I think they need to be considered. We reconsider that. So that's my focus, is not writing new sections, but working on the existing bylaw. I indicated at the October 6th, it's October 6th, yeah, meeting is, I could foresee the board being in a position of being able to take a reformatted, updated zoning bylaw without the new provisions to town meeting in spring of 2022. And then in spring of 2023, taking new provisions to the town meeting.
That aren't in there already.
They're not in there yet.
So we're still talking about doing, updates on everything that's existing before town meeting in the spring.
Yeah, that's a reasonable target to aim for.
Okay, one thing in particular, I know I'd emailed the group, but that working with the housing production plan, and, the housing authority is very interested in particular, the inclusionary, that the big thing is that, 10 number for the developments right now that's in there. So I don't know if we're talking about making changes like that now, right, during this pass. I know last time you had mentioned something about getting this past the formatting, because that would get that passed and then deal with things that may be more controversial.
Yeah, what I would suggest you do is take to town meeting in spring of 2022 a reformatted codified zoning bylaw that basically can say we're making no substantive changes. That is a motion town meeting, they approve that. And then
In other words, it's just organizing.
it's just organizing it into a systematic structure.
So somebody can actually understand it.
Right. And then we're on change, then these are articles to change the zoning bylaw substantively by adding items in there or by deleting items.
For 2023.
Right.
Okay, so we wouldn't be doing any of the substantive changes for next spring?
I would not recommend it with the possible exception of multifamily. I think that is a significant issue that needs to be looked at.
So can you speak to that a little bit?
For instance, when you look at the recreation requirement, there's none required for one-bedroom and elderly housing. You have to have 500 square feet for two-bedroom units and 2,000 square feet for three-bedroom units or more. That's per unit. So it's not a straight line progression, it's up like this. What it basically says is, we don't want somebody doing three-bedroom units. And three-bedroom units tends to be a word that says, oh, we don't want family housing, we don't want that type of population.
Three-bedroom, that's a very common family size.
Right.
2 little kids and...
Right. And that's the type of provision that anybody looking for exclusionary zoning zeroes in on what does a community do to discourage three-bedroom or family units. And that type of approach to it raises that question. If the bylaw said for one bedroom and elderly, you had to have 250 square feet for each unit. For two bedroom, you had to have 500 square feet for each unit. And for three bedroom, you had to have 750 square feet for each unit. One can make a rational argument if there is a progression. You're adding 250 square feet of recreation space for every additional bedroom. But that's not what your bylaw currently does. It puts a significant burden on anybody developing family housing, especially when combining it with the buffering and screening requirements that apply to those type of developments as well. And then you have the parking provision that is greater on 2 and 3 bedroom and than is on subsidized elderly. So I think there's, and I'm not saying you need to increase the parking on anybody, because there's a very strong line of thought among a lot of planners that parking requirements are too rigid already. But that's, so I meant
Overly designed or overly...
over-designing.
Yeah.
And I would, in looking at the multifamily, it specifies in there that for parking, you're going to have 200 square feet of parking for each space and then the 100 square feet for maneuvering. One could argue that that's overly compensating for it, and I'm not sure you need. No, I've used as a general practice in trying to identify how much a parking lot would encompass. 180 square feet for a parking spot. Let's say another 10 times 9, another 90 square feet for maneuvering space. Some would go 108, 110, but that type of rule. But I've never seen it specified in the zoning bylaw that it had that much space. Usually you just lay out minimum parking spot space that'd be at least 9 by 18 or 9 by 20. And then the driveway must be at least 20 feet wide, or if it's back to back, or it can be narrower if it's all one direction angle parking, that type of thing. And then it's up to the engineer to design it.
Right.
And whatever the parking area comes out, the parking area comes out. and not specifying the square footages that they have to use to come up with the area.
Sarah, you got probably multifamily dwellings have come up quite a bit probably in your discussions, right, with that board, huh?
Yeah, and just, I think that'd be a good one to tackle. So you're talking about basically having the bylaws as all the edits, all the reformatting, and then also present multifamily separately from that, just,
For multifamily, what I'm going to do is I reformat it, and then I'm raising questions about it that I think the board can discuss and decide how it wants to proceed.
Can you insert anything from the affordable housing component on that, or are you gonna wait till 23 on that?
I'd have looked to see what you're talking about submitting.
That's the inclusionary bylaw, right?
There's two approaches that can be taken. One, you can do an article that simply reformats everything. And then you can have the next article being one that amends substantively. And the reason for doing those as two separate articles is you want the first one passed.
Yeah.
You don't want the substantive changes to lead to a defeat of the codification and reformatting article. And I see it very critically that we get the reformatting codification done and then tackle the substantive changes. Because I would expect there will be multiple articles on substantive changes.
yeah, so I would say, I mean, based on what we've been talking about, the housing production plan, both the inclusionary and the multifamily, if when we go through them, I know they're both on your list that say, drafted, formatting, we as a board, I would think, should decide if there's something that's a substantive change that we want to have for next year. I just think those are two that, the sooner the better for some of those changes. I mean, what you just said about the square footage for a three-family, that basically makes it so you can't have apartments for,
It makes it very difficult.
I mean, when I first got married, I lived in an apartment in Holyoke that was 3-bedroom, and it was 1,200 square feet, and it was just my husband and I, but it was quite spacious, we felt at the time, you know what I mean? It's, I don't know,
Well,
that's just a
and
offshoot, but,
And the concern I have is the recreation space that's required. Now, when you talk about 3-bedroom and you're requiring 2,000 square feet of open space, recreation space for each unit,
That's a lot, yeah.
that's a lot of land.
Great room for each.
Each unit comes with their own park.
Yeah, and
Typo.
And then compare that to only 500 square feet for 2-bedroom units, it's 4 times as much, and then none for 1-bedroom and elderly.
Right.
And I would argue that I'm in that elderly group, and I would argue that we want our recreation space as well,
right.
and need it. And they really need it. It's been demonstrated that part of the big issue with the aging of America is the lack of socialization, and therefore, and that's largely the lack of recreation areas that are geared towards my population group, the elderly.
Well, that's why Cindy was a big proponent of that pickleball court.
Absolutely.
Everybody wants a pickleball
Absolutely, and it
court.
wasn't just me, it was a lot of people.
But, I get back to my question, so are we all on board that, yes, we're focused on formatting, codification?
Yep.
Okay.
Okay.
And I gave you in budget sheet what I see as estimated cost for, I expect it would cost to complete those tasks.
But I support what Sarah just said, that having the inclusionary bylaw update, once we have a chance to discuss it, be perhaps another warrant article, or along the lines of the multifamily one, because those are, they go hand in hand, in my opinion.
And I would change inclusionary bylaw, the title of that section from inclusionary zoning to inclusionary housing. I see
Oh, okay.
I see inclusionary zoning all the time, and it's really inclusionary housing. You're trying to have the housing be all-inclusive and not Because you're not trying to combine retail stores in with it, you're trying to combine different types of housing, different housing prices.
Yeah, just while we're talking about that, because I've gotten a couple questions from the Housing Authority, when do you think we'll be reviewing those multifamily and inclusionary housing? Just so I can,
I'll have the reformatting items to you this month,
okay,
so we could discuss them in December or whenever you want to.
okay.
Would it make sense to have a joint meeting with housing at the time for that particular discussion? Maybe?
I think it just needs to be the planning board myself.
Dave's expressed significant interest, so I know there's rules if they all come, we have
They have to post
Has
a meeting.
to be a joint meeting. I can ask the Housing Authority, you know, next time we're on a housing production plan, if they all want to come.
They really want their voice heard.
Joint meetings are a real tricky subject. You really can't have a joint meeting. Reason being is if the housing authority posts them having a meeting and you're having a meeting at the same time, somebody's got to take minutes for each one of them. You have to call each one to order. It becomes a logistical issue. However, the planning board can have a meeting and invite the members of the housing authority to attend.
But if they have a quorum, don't they have to post a meeting? That's our understanding. If there's- that's
Not
No.
to a public meeting.
Either come to a public meeting that's, my understanding has always been, I used to have similar understanding, somebody corrected me a while back, that if it's a public meeting of the planning board, the ex-board is not taking any action, but is merely being, the members are merely being invited to attend the planning board meeting. And those individuals can voice their position.
Okay.
Their board is not taking action, is not making any motions, is not engaging in discussion for their agenda items, and merely participating.
I actually think we have operated differently here, because I know of specific circumstances where more than one, a quorum of the other board showed up and were told to leave because it was constituting a quorum, it wasn't posted as a meeting, so therefore, we can't have a quorum of the other group, whatever the board was, you gotta go. And it was very offensive to certain people.
I would defer to how your town administrator wishes to have that handled.
I would,
He handles it as if there's a quorum, they have to call the meeting. Last select board, you had to have the library trustees.
That's
There was
right.
a presentation about how they need funds. There was, it wasn't the library trustees having a meeting, but they wanted to be in part of the discussion. So
They had a
had to
quorum,
call
so
the
they had to call a meeting.
If they both post, they both have to
Yes.
take minutes. And I'm not sure how the housing authority is going to function within a planning board meeting in terms of them having discussion, because you can't have another group have a discussion in the middle of another board's meeting.
what precludes them from being residents? They can be board members, but they're here as residents to engage in the conversation. I'm a little
I think this is a
confused on
discussion to
that.
have with the town administrator.
Hmm?
I think this is a discussion to have with the town administrator, because he's the one who knows how the town has been running them, and I would want his opinion on the matter. No offense to you, I just wanted,
Yeah.
No,
let me know.
Yeah,
I
I
just-
agree.
I
mean,
just think that, how can you control, say, for instance, if 4 of us or 3 of us showed up at a select board meeting one night or a conservation meeting, and we were just, got up to the podium as members of, as private citizens making a comment about it? How is that wrong?
Because you take them in the minutes, you take attendance, so people know who's at the meeting.
Yeah.
If there's a quorum, it can be construed that was considered a planning board meeting in conjunction with select board meeting.
Well, I just think we have operated differently here, because I know of specific circumstances where more than one, a quorum of the other board showed up and were told to leave because it was constituting a quorum, it wasn't posted as a meeting.
I agree, it could be construed there. I also would suggest that if the other board posts, then they have to take their own minutes as well. And they had to make their own motion to call to order, their own motion to adjourn.
They did.
Yeah,
They did all
That
those
they-
things. They did all those things, yeah.
yeah, we've done that, we did that with the library trustees, they just go up and they call it as their meeting, and then at the end, they say, and we're adjourning our meeting.
Are you gonna ask Ed for that, or do you want me to
No,
ask?
I can ask him, I have no
Yeah,
problem.
yeah, ask-
I don't have an opinion, I'm just saying, I think that's how the town has run it, I think that's.
No, but it'd be good to get a clarification on it.
Lots of examples. of
We've
that,
done it
yeah.
we've done it before, and I've done it in Northampton too, but he's right, you've got two different boards, and someone, if the housing authority is coming here, then I'm chairing the meeting. They're here with their members taking attendance, as he said, in minutes, and then we engage in the conversation, or Richard is there and whatever. But then, when they have to vote to adjourn,
Mhm.
we vote to adjourn, separately, type of thing. Or when they're done with this discussion, we have other business, say, okay, this part of it's over, you adjourn your meeting, and off you go, and we continue with our meeting.
Yeah, it's happened, I can think of a handful of times, yeah.
So maybe, obviously, this is something that'll have to be resolved long-term, but in terms of this, maybe for the first week of December, or December 1st meeting, I could ask the Housing Authority, when I speak with them, if two of them would like to come, or if they'd like to have a joint meeting, because that sounds like kind of the options, right? And it's kind of their call
Yeah,
at this point,
wouldn't
right?
that be a way around it? Because couldn't the representatives from the board, or the ones that wanted to come, a couple of them, but then if there was other questions from members, have them submitted to them, to ask at the meeting?
Right, so it's kind of their call. There's only 3 of them, so,
Oh,
It's
Not like, it's not a.
I didn't know they had not less than 5.
right, so it's whether 2 come, or if all 3 want to come, we'd have to do the joint meeting thing.
Two would be quorum.
No, two come, you'd have to join, they'd have to post their meeting.
Oh, because that's a quorum when you only have,
Yeah, but how does it, not to bring up another, but how about annual town meeting?
we're all there.
And we're all there.
Yeah, they're in the legislative capacity.
I don't know the answer to that. Everybody shows up at town meeting, many quorums.
Yeah. Are you taking notes?
That's good, Paul. I don't know the answer. So why don't you ask Ed what he thinks, yeah, yeah.
I'm asking, I don't have an answer.
You should ask about annual town meeting, see how he answers that. Very curious.
Yeah, there is legislators.
There's a difference between private citizens going up and saying their opinion versus this banter back and forth, which is considered discussion. So when you're having a meeting, you have an open discussion, and then you close the open discussion, and then you have a vote. So that's kind of, I guess, what happens at annual town meeting. But you're not having an open discussion, you don't have people having a conversation.
Right,
And
but-
people go up and state their opinion, and then they sit down.
Yeah, but there's people that go up at an annual town meeting and speak on behalf of a planning board, on behalf of a select
As
board.
representatives,
Yes.
yes.
So, but there's other folks in the attendance that are also members, so how does that not conflict with that idea?
Because they're not having that back and forth, that discussion that we are right now about.
They have to be quiet.
Does that make sense, I guess?
You gotta bring it up with him and ask
So-
him. That's, yeah.
Well, we've got 2 meetings in December, and really, too, as we go on here, as I said to you before, I'm not adverse to, provided I have members that want to attend, to post special meetings to keep the momentum up here. But we meet on December 1st and 15th. Were you planning on having anything for the 17th?
No, I was going to mainly have for the first,
First, okay.
and then that'll determine whether or not we need to discuss it further on the 17th. My guess is it'll be sufficient number of items that you'll want to have further discussion on the 17th, 15th rather.
Wait a minute, the 17th is this month.
I mean, I'm not going to have anything for
Right.
for this month, it'd be for December 1st.
15th, right,
Right.
1st and 15th.
So you will have things before the 1st, and that'll include
Yes.
multifamily and inclusionary.
Yeah, and
We'll do another batch for the.
I'll probably get to you by the 17th, just so you have plenty of time to review it all before the 1st, and we can discuss it then.
Okay, you all set? Richard, anything else you got to cover
Um,
tonight?
No, and I said, you talked earlier about the budget issue, and
Yeah, I'm gonna, just so you folks know that I met, Cindy was here, she knows, and Joy was, the biannual meeting of the boards. I came last Tuesday, Select Board, just gave them a brief overview of what we were doing, but I did emphasize about the financial cost that this was going to incur, and we didn't have the funds for it, so I was going to put them on notice that I'd probably be looking for some money to complete this thing by 2023, once we get going.
Did you get any results of what is in the current?
No, I
Planning
still have
board?
not heard from the present accountants. They still trying to dig their way out of the mess?
Yeah,
I think they're focused on 2022.
that's
Really?
I would have a discussion with, I know that they approved something for conservation.
But I mean, can I get a report of what the balance is in that account? Ed said he was gonna get one. I haven't seen anything, but I was
I
hoping.
think you should put a request in
Yeah, I think we're
And-
into Bradley.
but just,
and copy Ed on it, because that's applying all across the board. Nobody knows what their balances are.
Yeah, well, yeah,
I'll-
no one knows what their balances are. I would request that in writing.
You got
and
your
CC Ed.
contract signed.
the contract, as you recall, has a $5,000 cap on it. And will be at or above that $5,000 cap for the end of December probably.
And how you wanna handle that? Do we need another extension from you?
We need to do an amendment to the contract to change the dollar amount from 5,000 to whatever you want to put it to.
Generate the amendment, or shall we?
I can do draft an amendment, I just don't know what amount to put in there.
Right now, you're looking at, to get us through, what do you think you'd be comfortable with here?
If it was up to 10,000, it'd be more than enough.
All right, so write that up for me,
Okay,
and by that time, maybe I'll know what our balance is.
Yeah,
Account balances.
I would oppose signing anything else
Oh, no,
beyond, until we know what's in the account.
no, but I want him,
Your safety and for what the board knows, because
Yeah.
it's concerning to be signing, committing to paying,
yeah, you,
paying you, and we don't know what we have to.
that's my concern.
Yeah.
You can't, and I would not expect the town accountant to sign the contract unless knowing how much money is there, because they're signing as to availability of funds.
draw it up for 5,000 then, and I won't sign it, but I want you to sign the amendment, and send it along, and then we'll approve it once I find out what we've got.
When are we getting our paychecks?
Mine are only about 15 years overdue.
Okay, I'll draft it up and send it to you.
All set?
Yeah, yes, sir.
Thank you, Richard, for your
Thank you.
time, very informative.
Thank you.
We'll see you next month. Have a nice Thanksgiving.
You too.
Thank you. Let's see, there was no building permits tonight. John Furman had sent me, and I think I forwarded to you people, a communication about Fitch Farm Way. They put the final coat on, and John didn't have any problems. He said there were some imperfections on the berms, but he felt that asking them to try to fix them in any sort would do more damage than not, because then they're all bound in by the,
It's intrusive to the
right.
roadway structure.
Right. And he said, you know, they're just scarred up a little bit, but not to the degree where they're severely damaged, but. So that went through, and he had picked out trees. John was gonna suggest to him trees. He suggested not maples or oaks because of the size they grow, and the roots because they could impede the sidewalk, that side the sidewalk's onto, so.
Didn't his LA identify what tree plantings?
He didn't, I asked Brian, and that's what John was kind of chuckling about. He said Levesque, his architect and whatever,
His landscape
is a
architect.
landscape architect, but yet he did suggest that he type of trees, so.
I find that hard to believe.
That's what Ryan even told me that too, so John was gonna suggest something. Mr. Bucky Sparkle, about 32 High Street, the Felton property that seemed to be such a hot button. I reported to the select board on that, and it's still an open permit, and there really wasn't any issues that we could dwell on right now that would satisfy the neighbor. The boulders aren't of any issue. That's landscaping. And as I said at the select board meeting, unless there's an earthquake, they aren't coming off of that hill. He sent pictures that I forwarded to you people of all the areas where they had done stormwater management in the last 9 months. And he's asking, because of the time of year it is now, he's asking for an extension. He's requesting a 1-year extension for that culvert. And here is his letter. Though the rain has subsided until, of course, a few days ago, many intermittent streams are still flowing. This was the case on another job I just visited, and it's also the case at High Street. The Conscom will not allow the culvert to be installed while the stream is flowing. So with a week of predicted rain and the end of the planting season upon us, it is highly unlikely Mother Nature will permit the work to happen this year. And as such, on behalf of the owner, Greg Felton, I am formally requesting a 1-year extension to the stormwater control permit issued on 1/8/21. So I'm going to ask some of you engineers here especially what your feeling is on a year extension. Is that a little bit too much, or should we shorten the belt on that? Which is interesting, the Conscoms will not involve, allow it to be built while there's water flowing, so what do we hope for? Spring is usually not a dry time of year, so we can expect that between now and probably mid-May, that there's gonna be still running water, and then we're gonna hope for a drought in the summer?
I mean, August is probably, I have a little intermittent stream in my front yard, and it has been running all year, but it's typically August is when it's dry.
So,
But I will say this, because I share the stream with Sarah. There are years when it's dry as early July. It depends. Maybe
Yeah.
it's wetter where you are because you're a little bit
Yeah, but no,
upstream
it's
from me.
sometimes as soon
So
as July.
I wonder if it's possible, because this has been such a hot button, and I just wonder if we can put a requirement on there, August, or if there's 3 weeks of dryness, where things really dry out, no rain for 3
yeah,
weeks. I don't know
I'm
if any,
reluctant,
like,
I'm
could be written
reluctant to
anything
give
like
a
that.
year, because that's a year from now. That's,
Yeah,
to me, a
it's
little bit
too
too
long.
long because of what's been going on up
Yeah.
there for a long time now, but what do you want me to go to?
So this is just this culvert, right? I mean,
It's Yeah, it's a culvert, box culvert that's gotta be installed, yeah.
Right, I mean, it doesn't seem unreasonable. It's been wet this year, having through next August or something. That seems reasonable. All the other issues up there are I guess are kind of separate. I'm not sure how to necessarily tie them into this personally, but.
So, this man came, and he was irate. And Paul was here, Sarah was here, I was here, Dan.
Mr. McNichol?
McNichol, and Mr. Harris was here. And he's the one that recommended to go to the select board, because we asked him for his opinion, because we did the best we could to allow the discussion and try to come up with some kind of resolution. Finally, Paul, right here, said, what would you do? And he said, you gotta go to another authority. That's what happened. So, as far as all the other issues, I mean, Conservation Commission has their jurisdiction over the wetlands in the districts, in the distance. We have the stormwater thing. And then the Health Department has the potential for the fact that he might be living up there or for some period of time. And I think I understood from you in your report, or Select Board already has asked Health Department to be aware or monitoring or whatever. So that's another issue.
What is their opinion on this?
That's right.
I guess I should just email them and be like, what's your opinion?
That's right. And do we know if the building inspector's watching any of his responsibilities up there? And then I know Randall also weighed in.
Like, does it make sense to be permitting things, but he's not gonna get a permit for other things?
If the box culvert isn't completed, he's not gonna get a building permit. Say, for instance, he goes down and files for him, and furthermore, this board won't sign off on it when it gets to us because the other thing isn't fixed. So he's stuck right now because that's not installed. But where I was coming from is that we've been driven down our throats for so long about how we are the stormwater authority. Then I said, well, and Mr. McNichol evidently was quite adamant trying to find out who was responsible, who's the decision-making people. Well,
We told him he wasn't around that day.
in my mind, it's us, because we're the authority. But since the permit's still open and the box culvert hasn't been installed, and yet his 1 year is not up yet, it's an open, and Paul, I think, referred to that. So what else do you want us to do? The other issues are out of our control, the trailer and the conservation stuff. So just because there's a neighbor that doesn't like what he sees and is afraid it's gonna happen again, well, the town highway department had no trouble with it because there's not any landslide coming across High Street anymore, so evidently what he did with the mitigation worked. So I really don't know. The guy just doesn't like what's going on there, but we're only in control of the stormwater.
So with this box culvert, if we say, no, you can't have an extension, and Conservation Committee says you can't install it while there's water flowing, I mean, I don't know what the guy, in fairness to him, it's other issues, but I don't know what he does, like, it's wet.
And
Like, his hands are tied with the Conservation Commission.
Exactly, yeah.
Because that's their purview.
Yep.
So,
Yep.
I don't see what else.
So what do you want to go to, like, you want to put a date on it to August 31st? Or do you want to go to July 31st? What's your feeling?
Well, look, I almost feel like if we put it to July, he's gonna be in front of us, or he's gonna be asking for another extension, potentially.
The only thing I said to the select board is, and it's in the provisions somewhere where I was reading recently, that, we don't want to grant the extension, and if it's not installed, okay, so he comes back for the extension. So you give him a drop dead date to install it, and if it's not, then fines should be imposed for every day that it's not there. That's the only teeth you have outside of that.
Well,
If you don't grant him the extension, does he have to come back and apply again when he's ready? Or is that it?
Well, he can come back with a half-hearted excuse again, and for some reason or other, but if if there's a dry spell, and I guess with you guys having a stream, I probably would defer to you, say, hey, how's the stream, you know? I don't know how many times, or if we're even allowed on the property, if we'd be trespassing by going up checking it, or does Conscom check it, or how that works, but.
So I guess I wasn't involved when this whole application first came in, but right now, there's no building permit, so he's not building a house or anything. He just wants to put this box culvert in to allow access to build a house?
No, that was a condition because he did erosion. He created erosion up there and, over
A whole mud
an
flow.
acre without a permit. And when we got up there, that was part of the issue there because when we were up there, he replaced an old culvert pipe himself.
Yeah.
And put something in, which was a no-no.
Right.
So he had major issues going up there of stuff that he just did on his own without any supervision.
Right, but I guess my bigger question is this. Technically, the culvert, as I remember, wasn't really our purview, that's a Conservation Commission.
So we conditioned it.
Well, we conditioned the fact that it had to be done in a certain manner.
Precast.
Right. So, there's other site features that we have purview on. And where did those other site features fall in?
Do you see the pictures that Bucky, that I sent along?
Yeah, I saw the email, I just don't know how that all relates to,
Well, he had given pictures of the mitigation measures they took in a lot of different areas on the road and the driveway and stuff like that. So getting back to the date, what do you want to do for a date?
Why can't we do it, like, say, either July 31st, something like that, or come back for another permit, and then we would have real knowledge of how wet it had been. You know what I'm saying? We all live in town here. We know how much we will be able to say, yes, you're right, it's been X number of inches of rain, if they didn't do it. But if there hasn't been any rain, then he should have put it in.
Well, I'm inclined to go 9 months, not 12, which would bring it to August 31st.
Okay, fine. I'll go with August 31st.
Yeah,
Sarah?
that's fine.
Paul?
let's do it.
Motion to grant the extension for the culvert installation at 32 High Street, Greg Felton, to August 31st, 9 months. Somebody make the motion?
I'll move to make it August 31st, as written.
Is that Cindy or Sarah?
That's Cindy.
All right, second?
I'll second it.
Motion's made and seconded, all in favor? Aye.
Aye.
Aye. Do we want to do the thing you said, and if he doesn't put it in by that day, put a fine on each day?
I will put in a paragraph of that effect.
Okay.
So, not to be the wet blanket here on the fine,
What?
Then it rains.
What?
not to be the wet blanket here on the fine discussion, but
Or legal,
our legal representative here can.
what's the
can
language
chime
I
in
should,
on
do?
this.
Or legal,
Not my purview, but go ahead.
Well, the point I'm making is there's no mechanism, once again, in any bylaws about fines, so we're just gonna,
in
In general.
In general, is there,
yeah, so we can't just arbitrarily, I don't think we can arbitrarily just say, we're gonna charge you $1,000 a day because you did. There was no condition set forward previously.
I'll just put, or legal measures will be taken. Yeah, right.
Can anybody do that? Can they arbitrarily, for example, could the select board say, under this circumstance, this person has been warned time and time again, therefore,
I don't believe so.
you don't think so?
Based on my experience with conservation commission, not on legal expertise, because we had so many issues with different properties and we were not allowed to find them until we had a very defined bylaw that described the
Yeah.
fines and the time and the notice and everything that we had to do before and the exact amount. Yeah, so I think it has to be very defined.
Right, so like, there's, and I'm not sure what we do in Southampton, but in other towns, communities, there's provisions where they have to pay a $10,000 bond or whatever, a $100,000 bond, depending where you are, and then the scope of work, that I believe is already predefined in the, policies and procedures section
Mhm.
that I think has to be somewhat tied back. So for us to arbitrarily say something, I don't know.
I guess we can't, yeah.
No, it's, I was thinking out loud on that. I wish they would address that, though, and get impose fines on stuff.
You can make a policy about it.
I'd have to go to town meeting to get it done.
All right, next order of business here, I'm gonna make out a warrant. Where is it? I'm gonna make out a voucher for Richard because last meeting, we had approved his first bill that he sent was $1,500 and change. Here it is here. Last meeting, we approved $1,537.50 for 20 and a half hours of work since he started with us on September 15th. So that one I've already been vouchered, and it's in the accountant's office. And the next one here he has for October, total $1,585.64 for 21 hours of work, stuff that we just saw tonight. So I want a motion to approve his October invoice of $1,584.85.64.
So moved.
Second,
Second, Cindy?
yeah.
Okay. All in favor? All right.
Aye.
Aye.
Next, and this just came in tonight, I got it in the mailbox, from Amanda Zadonis Kemp, attorney at law in Easthampton. It's a carbon copy that she had sent the select board in compliance with Mass General Law, Chapter 61A, Section 14. Enclosed, please find a copy of a letter dated October 25th, 2021, directed to the Board of Selectmen requesting a waiver of the option to purchase a 20.36 acre parcel on East Street, highlighted on the enclosed assessor's map, which is subject to the provisions of Chapter 61A. And by this letter advising your board of the request made to the Board of Selectmen so that you may make a recommendation to the Board of Selectmen if you wish. So they're asking us if we have any interest in that land as a board, and
Um,
I think where that is it, where's Middle Road?
Wasn't it highlighted?
That is
It's right there.
Here it is, but I'm saying this is East Street, where is Middle Road?
I have the property I'm showing Sarah right here.
What's that say, something
This
extension?
is upside down.
Moose Brook?
This is Strong Road.
No, there's a cul-de-sac
This
there.
is-
What is that?
Hold on, get upside down.
East Street over here. So like the library's down here.
Yeah.
Are you with me?
Yep.
And then
Oh, okay.
Woodbury Field, I think is here.
Okay.
Shit, that's big.
And it's this lot right here. It's kind of this shape.
Oh, interesting. Okay, yeah, I have a friend on Sophie Circle.
So there's other people in town.
So could, you guys can see it better on your,
What is the lot number again?
parcel, map 29, lot 55.
Wait a minute.
Oh, is that Whispering, that's what that is, Whispering Meadow,
Oh,
isn't it?
it's this one. It's this one here.
That's the one that
Okay.
rebuilt.
It's
And
a pretty good size.
what?
Road
It's a good size
coming
lot. I
from
mean, lot's 29.
Center
Yeah,
of
and
town,
then this
Whispering
is
Meadows
on
here, so it's just before the
Okay.
orchard, then somewhere in there.
Okay. So,
Right.
so, as, the Open Space Committee has not met since this letter was received. So there is no opinion by the Open Space Committee, but what I understand, and I got an email from Joy, that this might be of interest to the Housing Commission and the Open Space Committee, and I heard Richard saying, you know, we have to think about other criteria. Is it, you know, contingent to other open space? Does it connect with parks or something? So we haven't had a chance to discuss this.
The only thing that I would say then is, as a board, that we have no interest, but we would defer to open space and housing.
Okay.
Is that,
I'm in agreement with that.
everybody in agreement with that?
Yeah.
Do I have a motion?
You want to make a motion?
Motion to, that the planning board has no interest in this parcel, but will defer to open space and the housing
So moved.
partnership.
Second.
All in favor?
Aye.
Aye.
Any other reports of committees, that there's anything of interest that we should know?
Coming up on the 18th, which is the day after our next meeting, that Thursday, we're having our second public meeting for the housing production plan, which will be Ken Comia from PVPC presenting and talking about what goals will be presented in the final housing production plan. So there'll be flyers, and I'll send you guys an email with the Zoom, and it'll be virtual.
What was the date again?
The 18th of November. It's a Thursday evening.
So that'll be Zoom, yeah.
It'll be Zoom, yeah.
Do you know what time?
It's 6:30.
6:30?
Okay, I think that's all I need to cover tonight. We have a motion to adjourn.
Motion.
I didn't give a report.
Oh, I'm sorry, Cindy. Got anything?
So CPC met tonight and approved to support the match, well, it's not exactly matching, it's like $86,000 towards the park grant, PARC, which is the renovation, redevelopment of Conant Park, including accessible pathways. But one of the more interesting topics is the installation of a splash pad, which it's got many considerations, but it was approved to go to town meeting, to go on the warrant, that we would support that. There was a lot of considerations there. They also approved that utilizing administrative funds, does not have to go to town meeting, to get an appraisal of a lot up above the current town-owned property going off the end of Old Wolcott Road. It's
What was the name, what was the road?
Wolcott
Wolcott?
Road.
Yeah.
And it sort of ends in private property, going up, sort of up
Yep.
the mountain.
Yeah.
There is town-owned property that's always been called Durrell's Path, but now it's called Great Mountain Trail. And the land above that is privately owned, 40 acres. It's not a public road up there. It's essentially landlocked. And the Conservation Commission is really eager to own that land. So the CPC supported to have administrative funds used for an appraisal and for a $500 down payment, which would then be returned to CPC funds if the sale went through. We don't know if the people are going to sell, if, the whole thing would have to be written, this offer would have to be written with all these contingencies put in there, contingent to approval in town meeting. The assumption, we're not sure, is that this might be only $1,000 per acre, so it might only come to about $40,000. So CPC money, we hope, can be used for that. But it's really beautiful land up there, if anybody's ever walked up there. The town-owned property was blazed and new trails were put in this summer by the Student Conservation Corps. It's really nice, it's gorgeous. So that was the other piece of business that happened there. Guess that's it.
Thank you.
I move to adjourn.
Second.
9 o'clock.
All in favor?
Aye.
By the way, how long did you meet with Richard the last time? Was it 9:30?
It was 9, it was a few minutes after 9, I
Yeah.
think.
He gets paid for travel time.
Yep.
What else did you just say to me?
That's why I'm glad he just
know.
highlighting the areas
We were talking about
that need to be addressed rather than reading everything.
Yeah.
Exactly.
Yeah, I
Thanks,
don't know.
Polly.
I think that, I don't know. I know I said something and I can't remember. No, that's
I
fine.
couldn't hear you. I'm
No,
sorry.
all right.
Yeah.
Good night, everybody.
Did you have a good vacation?
Yeah, Sanibel Island.